so they can represent themselves in court proceedings. You can go in person to the Regional Justice Center. The Civil Law Self-Help Center is located in the first floor, which is at 200 Lewis Avenue. It's open weekdays from 8 a.m. to 4 p.m. You can also navigate to our website, www.civillawselfhelpcenter.org, and it has a bunch of great resources and forums and information that you can get there as well. With that, I'm going to turn it over to our law students to begin the presentation. Again, please hold your questions until the end of class, and I appreciate you all for attending today. Thank you.
Hi all, thank you, Aaron. So today we're going to talk about tenant's journey. Well, starting with tenant's journey. So cover legal issues at every step, such as things to think about before moving in, problems after moving in, terminating a tenancy and leaving the property, and problems after you move out. Before and after moving. So there are no legal protections in Nevada from crazy high rents, application fees due to a lack of available housing and a tight rental market. So some legal protections exist even while tenant is apartment hunting. In terms of discrimination, so Nevada and federal law protect against discrimination. So a landlord can't refuse rent or negotiate, offer worse terms, require additional fees, or tell a tenant that the unit is unavailable because of a characteristic such as race, religion, color, national origin, ancestry, familial status, or sex, and Nevada exclusive is sexual orientation, gender identity, or expression. A landlord can't refuse to rent to a tenant with a disability just because a tenant has a service animal, needs reasonable modification to property, needs reasonable changes to rules or policies. Actually, Aaron, I had a question. If I have a service animal, if a tenant has a service animal, can that be used as justification for disability prima facie to say I have a service animal and I was discriminated against, or to prove something?
So if you have a service animal, your landlord typically will take some type of action against the tenant. So they may try to evict the tenant or charge them a pet fee, which they're not permitted to do under NRS 118 and under the Fair Housing Act. If the landlord does either of those things, and that's discrimination, but the tenant may have to present a letter from a mental health provider that that animal was a prescribed service animal or emotional support animal. So simply having a service animal is not enough. The landlord has to take some type of discriminatory action against the tenant, and then the tenant must provide evidence that it was a service or an emotional support animal.
So if a landlord tried like charging a fee, like a service, like a fee for a pet, and the animal is a service animal, and the landlord still goes ahead with the fee, you would have to prove in court with some mental like letter or like proof that.
Well, typically you have to give the landlord the letter, and then if the landlord continues to charge you the fee, then you could file a complaint for discrimination.
Okay, cool. Landlords in Clark County can't discriminate because of a tenant's source of income or previous eviction resulting from code-related income loss. A tenant can file a complaint with the Nevada Equal Rights Commission, the U.S. Department of Housing and Urban Development, which is referred to as HUD, and the Clark County Code Enforcement. Now, budgeting wise, so it's important to understand, your incomes, your profit losses, how much money you're going to have coming in and out, and going forward, how much it's going to cost to move in. Total cost of renting vary by landlord and not always apparent, but can include things typically such as base rent, utilities such as electric, gas, water, internet, and cable, renter's insurance, security deposits, and other fees such as with Aaron, like pet fees or garbage, pest, parking, and etc. But this will all be disclosed in the lease, so make sure you read it before you sign, because that will be binding and you want to know what you're paying for in addition to just the base rent. Less than 30% of tenants before tax income should go to rent and housing, so it goes into proper budgeting. Breaking a lease or an eviction can have lasting consequences such as damage to credit, harassment by collection agencies, lawsuits by landlord, garnishment of wages, or even an inability to rent another property. So keep that in mind. Make sure that you know what you're getting yourself into and you're able to properly finance your lease. Leases before and at move-in. A lease is a contract that binds both a landlord and a tenant, so don't sign it unless you understand, and if need be, talk to a lawyer. A written lease is required only if the lease term is for more than a year, so in that case, it must be signed by the landlord and the tenant is entitled to a copy. Once again, only if a written lease is only required if the lease term is more than 1 year. In terms of required terms in the lease must address the length, start and end dates, the amount of rent that's to be paid, the fees and the additional fees and deposits required, the people and number living in the unit, and several other, extracurricular things. Presume a lease term. So if the lease doesn't have the following terms, doesn't address the following things, the law presumes default number of people and pets, that the landlord would be paying for maintenance and trash. There'd be no charge for partial or late payment or dishonored checks, and the tenant must leave the property in the same condition as move-in, except for normal wear and tear. Prohibited provisions. So these are things that cannot be in the lease, and if they are in the lease, they are void, such as forcing the tenant to give up legal protections or the right to sue the landlord, giving up the right to sue the landlord. To confessing for judgment, which means admit to owing money that the landlord can collect without suing, paying landlord attorney's fees unless the landlord sues and wins, and giving longer termination notice than landlord. So all the following above are the preceding four provisions are disallowed in a lease, and even if they are explicitly written in the lease, they're void by law. Illegal lease provisions are void and could be basis for a lawsuit, right? So the landlords tend to use the same lease over and over and over, even though the law changes. So make sure to check your lease to know what's binding and what's not binding. Should you always have a lease? Well, it depends. There are some advantages and disadvantages. Advantages include it clarifies the duty and obligations of the landlord and the tenant. It locks in rent, fees, and utilities for the lease term. The landlord can change other terms with 30 days notice if new terms apply to all tenants and promote safety, fairness, convenience, protection of property. So even though you have your set lease and it's there, the landlord can change it with this little caveat. It gives you 30 days notice. And if they apply to all tenants and they promote safety, fairness, convenience, protection of property, kind of like a public policy type deal. Disadvantage is the tenant is bound just like the landlord, and then it's difficult to terminate early without liability. There's no flexibility with the lease. What happens if my lease ends? Well, landlord or tenant can give notice and terminate the tenancy, and they can move out or pursue an eviction. If the tenant remains on the property, it's considered a holdover. So if you have a certain lease and now your lease is over and there's been no eviction, or you haven't been evicted yet, or you're still on the property, now it's considered a holdover. What this means is that if your whatever stipulated agreement you had previously before the end of the lease, that stays. It retains until either you terminate or the landlord pursues an eviction or terminates the deal. So basically, let's say you had a month-to-month agreement, and then the agreement ends, the length of the agreement ends, it still continues on regardless of the lease ended. That's the holdover period. And if it's week to week, same deal. The landlord-tenant relationship generally is governed by a lease, except that the landlord can now raise the rent with 60 days notice for monthly rent, or 30-day notice for weekly rent. And there's no cap on the increase. So a landlord can increase the rent provided that the 60-day notice for a monthly rental agreement and a 30-day notice for a weekly rental agreement. And there's no cap, so they could put it whatever they want. Security deposits. Money held by a landlord to pay landlord for unpaid rent, late fees, cleaning costs, repair of damage at move-in, other than normal wear and tear. And that's always, I think it's a gray area. So be careful with that. You can't force a landlord to apply the deposit before move out, and if property is sold, the money must be returned to the tenant or transferred to the new owner, and the new owner is on the hook. Deposit can't be more than 3 months rent, 2 months if the last month is paid in advance. The landlord can't ask for additional security during the lease term. Plan that move in to get deposit back and move out. Yeah, so you should use an inspection sheet, like we mentioned, like get that through the HUD and do a walkthrough with a landlord or other witness, and write detailed description of damages, take photos, use the same process and move out. This is just to ensure that you get back at least majority or as much of your security deposit at the end of your agreement as possible, because like I said earlier, it's kind of a gray area with normal wear and tear, and you just want to make sure that the landlord isn't going to, try and take as much as a security deposit as possible, and maybe try and make up some damages that weren't there, that wasn't due to normal wear and tear. After a move out, landlord has 30 days to return the deposit or provide itemized accounting showing the deductions. Accounting must be handed to the tenant or mailed to the tenant's present or last known address. The landlord fails to or refuses to provide accounting, the tenant can sue for a double deposit. So if the landlord is going to deduct from your security deposit, citing certain damages to the property or this and that, they have to provide you a copy of saying what it was exactly. And if the landlord fails to provide accounting for what it was, and they still take away from your deposit, you can sue for double deposit. The landlord can counterclaim. If the landlord does counterclaim, the tenant defenses can include that the damages didn't occur, the deductions were not reasonable, or that deductions were not allowed under law. The delivery of unit at move-in. So at the start of rental term, the landlord must deliver possession to the tenant. And the property must comply with the lease agreement. Property must be in habitable condition. We'll talk about later the certain conditions essentially that are required for livable conditions. But in some, it's livable so that an average person could reside there. If the landlord fails to give the tenant possession, the rent stops till the landlord provides property that it complies with the lease and Nevada law. The tenant can give a 5-day notice to the landlord, terminate, and get money paid back. The tenant can demand performance and sue for possession and or damages. Landlord must disclose in writing or post on the property the telephone number of a person in Clark County that they can call in case of emergency, plus name and address of the person authorized to manage the property, person in Nevada authorized to receive notice, and the person corporation that owns property. Is this all or either, Aaron, for the person authorized? All?
For which
The top three? For the person authorized to manage property, person in Nevada authorized to receive notices, and person corporation that owns property.
Yeah, it has to include all three of those.
All three. So the landlord must disclose in writing or post on the property, telephone number of a person in Clark County, in case of emergency, and person authorized to manage property, the person in Nevada authorized to receive notices, and the person corporation that owns the property. I'm assuming that this can be, they can fall into the same person, right? Person can have multiple classifications. If the landlord doesn't disclose the before aforementioned classifications, a person who signs the lease can receive notices and lawsuits and perform the landlord's duties. And after demand by the tenant, the landlord can be sued for greater of actual damages or $25. $25? That's, I guess, yeah, you could get lunch, I guess. The landlord is obligated to provide essential services, like I said before. So essential services include heat, air, water, electricity, gas, door lock, and others, and to maintain the property in habitable condition, which means, not leaky ceilings and mold, things along those lines. It has to be code compliant, safe, and in good repair. To resolve essential services or habitability issue, follow the following 5 steps. Right. So if essential services you don't think might not be met or aren't being met and habitable condition requirement isn't being met, here are the 5 steps to resolve the issue. Step 1, decide whether the problem is essential or is a habitability issue. Because each has its own procedure, time frame, and remedy. Step 2, you mail the landlord a written notice. Keyword there is mail. So you send a letter to the landlord describing the problem and requesting repair. I think highly recommended to mail by certified mail, and keep a copy. Don't just send one and that's it. Keep a copy to yourself as well, or even send them the copy. And step 3, wait to see what the landlord does. So for essential services, the landlord must fix it within 48 hours or 2 business days. For non-essential habitability issues, the landlord must fix it in 14 days, 14 calendar days, which means no weekends. What's 14 calendar days?
So 2 business days don't include weekends or holidays, like judicial days. And then 14 calendar days just means how you count normally. So you include weekends, you include holidays, just every day.
14 days. Step 4, it's to enforce your rights. The landlord doesn't repair. So if they don't follow those dates, if you mail that letter for essential services and it's been 48 hours, or you mail the letter for habitability issues and it's been 14 regular days. Step 4 is to enforce your rights. The landlord doesn't repair, or if the time elapsed since the written notice. For essential services, you get the service somewhere else and you deduct that from the rent on your own. You get other housing until it's fixed, or you withhold rent only if you're current on the rent when the letter is sent. So you only withhold rent if you're already current on the rent, or you can sue. For habitability issues, you can terminate the lease and you can move out. You can pay for the repair and deduct from the rent equal to 1 month rent every 12 months. We can withhold the rent and sue. Step 5 is to wait and see what the landlord does. landlord will either fix or give an eviction notice. And if there is an eviction notice, the tenant must file an affidavit, which is an answer with the court, which is like a tenant shows up to court. I believe there are templates for this to be found online for free, in which you can file this with the court. You can assert a defense of essential services or habitability. You can assert a defense of retaliation, and you can deposit withheld rent with the court if it's a habitability issue. Retaliation after move-in. Is this you know? Is this 29? No, what number is this? Okay, last one for me. There's a question. Questions from Mickey. Questions are going to be discussed after Mickey. We'll get to you. Last one for me. Retaliation after moving. If the tenant complains to police about a crime, or the complains to the landlord or government agency about discrimination, violation of landlord-tenant law, or habitability/code violations not caused by the tenant, or the tenant refuses to consent to landlord's proposed rule changes, or the tenant joins a tenant union, or a tenant is a victim of domestic violence, the landlord cannot threaten or serve a no-cause eviction notice. The landlord can't increase the rent unless it applies to all the tenants living on the property, and landlord cannot decrease essential services. If the landlord retaliates, the tenant can sue for damages plus $2,500, and as a defense to eviction, an affidavit says answer. Yeah, see, 2,500 sounds like a real number.
This one's $2,500. Because other one's just a simple posting issue, so it was like $2,500 stat for actual damages. The $2,500 bears some heat with it as a punitive measure. Cool. Okay, hand off to Max.
Thank you.
Yeah.
So now we're gonna move into when, or if, hopefully not when, but if your landlord is abusing your right to move in or access to your property after you move in. So a landlord who rents to the tenant gives of possession and access. And I won't get into super specifics, but there's two kinds of possession. There's legal and physical possession. So it should be technically both. So like you should be able to enter the property, and then per your lease agreement, you should be able to be in there. And then access to the property again is just physical access to it. So after you move in, the landlord still can enter your property. They can without notice or without notice or consent in an emergency is the only time they can without notice. And then on a 24-hour notice during business hours, they can only access the property. Sorry. And then on a 24-hour notice during business hours, they can access your property to inspect it, to make necessary or agreed repairs and improvements, to supply necessary or agreed services, or to show the unit to potential or actual buyers/tenants. They can access your property through court order. If you as a tenant abandon or surrenders the property, they can access it. But again, as it says on the slide, we will discuss that later. And then they can also enter to clean or repair, typically at the tenant's expense, the property if the tenant failed after a 14-day notice to do so. So the landlord cannot abuse your right as a tenant to access the property or harass you. And the landlord cannot sue the tenant for refusing lawful entry into the property. And the tenant can sue the landlord for abusing their rights of being able to move in. Or not being able to move in, being able to access the property after you've moved in. So as a tenant, you usually cannot end your lease early without either the landlord's consent or without payment. But some leases do allow early end-in, or as in terms of like special situations or by buyout. And then if the tenant does end the lease early, the landlord must, and that's like a mandatory prescription on the landlord. The landlord must at least try to re-rent the property out so they can make that money back from the period that you haven't been there. And then if they do find someone, they can only sue you for the time the rental is empty. And then the law does allow the tenant to end the lease in some special situations and circumstances, and it limits the amount that the tenant does owe to the landlord, again, contingent upon if you do qualify under the law for the special situation. So the tenant can legally break the lease when the tenant enters the military after the signing the lease, and this is a federal law, it's not Nevada law. So the tenant, if this happens, must give written notice to the landlord, and the lease would end after the tenant gives written notice to the landlord 30 days after the next rent is due. And then the other time the tenant can legally break the lease is when the tenant is 60 years older or plus, or has a mental or physical disability and they have to relocate for care, which is not possible in the rental unit. So again, for this situation as well, the tenant does have to give a 30-day written notice within 60 days of relocating. So another situation that the tenant can break the lease legally is if the tenant is 60 plus years old or has a mental physical disability and spouse or their co-tenant dies. So this gives the tenant the tenant has to give in this situation a 60-day written notice within 90 days of the death of the co-tenant. And then lastly, a tenant or household member who is a victim of domestic violence or harassment, sexual assault or stalking within the unit can legally break the lease early. And then the tenant has to give written notice to the landlord within 90 days of the event. So for example, domestic violence or harassment that happens, and then provide a copy of a protection order, which typically comes from, does come from the court. So it can be a protection order, a police report, or an affidavit, which is basically just a sworn statement to the court, which is just the tenant just writing down, this is what happened, I'm alleging that this is true, of a qualified third party in official capacity. So when the lease expires, either the tenant or the landlord can end the tenancy by giving notice. So most leases do require a 30-day notice, but some require longer. So again, please, as Aaron said earlier, please read your leases and look what the notice period is. And then also follow your notice procedures in the lease exactly. So if you're sending notice, for example, the type of mail that you have to use, it could be certified, it could be the address of the landlord, etc. Improper notice, so not complying with what's in your lease and how to contact your landlord, letting them know that you're ending your tenancy, could mean additional month's rent. And then if you as a tenant do stay on your property after the lease ends, this is considered a holdover by the law, which just basically means that you're paying either month to month or rent to rent contingent upon how your landlord's gonna do that. And then, so now we are going to talk about, as I mentioned earlier, if you're a tenant, if you surrender or abandon the property. So the landlord can retake possession legally without eviction if the tenant does surrender or abandons the property. So if a tenant is surrendering their property, that means you're giving up your right to possession. This is physical possession. So to the landlord. So that means like you're moving out, you're handing over your keys, you can't physically access the space anymore. So abandonment, under the law, there are two tests. So the first test, or one, is presumed if the tenant is gone for half of the rental period. So it's usually 15 days that the tenant has abandoned the property, unless the tenant is current on their rent, or if you as a tenant has notified your landlord prior to this absence in writing of the intended absence. And then under the abandonment law as well, after 5 days, if the landlord serves the tenant after 5 days of eviction, the tenant's written notice of the landlord's belief of abandonment. Sorry, I just butchered that. So I'm gonna restart it. So if the landlord believes that you, the tenant, has abandoned the property, after 5 days, the landlord has given you written notice of that. You as a tenant can say that the belief is, or the landlord has to prove that the belief is reasonable, that the rent is not paid. And unless you as a tenant pay the rent and give the landlord the written notice of non-abandonment, the landlord can claim that you've abandoned the property. I apologize for that. Okay, so for eviction in Nevada, we have two kinds. There's summary eviction, which is the most popular. It's quicker and it doesn't cost the landlord much, or there's formal. So as a tenant, hopefully you won't have to, or as a landlord, hopefully you won't have to engage in this, but this is usually the sphere of what's going on. So for a summary eviction, it's most common, it's the fastest, it's easiest for landlords. So if you are a landlord, you only get possession of the property under a summary eviction, so you don't get any money damages. So you would have to sue separately in civil court. And then in summary eviction, it cannot be used in some instances. So for example, after foreclosure or for mobile homeowners or in parks, and that's just per statute, those have to be done under formal eviction. So moving into formal eviction, it's like a regular court case. So it can be lengthy. It's more complicated and there can be a jury trial. And then it usually requires a landlord to have a lawyer. So hopefully as a tenant, you would have one as well. And then the landlord in this situation can get possession to the property in tandem with money damages from the tenant. So for summary eviction, there's 5 basic steps. So first, the landlord serves an eviction notice to the tenant. And I do want to put a pin in this and note, it's not a formal service of process in Nevada. We're weird. So the landlord just has to post a notice on the tenant's dwelling, as well as just mail the eviction notice, and that as the court recognizes that as service upon the tenant. So during the notice period, the tenant has to respond to the court, which just means that you have to file an affidavit or just an affidavit to the court. And then after the notice period, the landlord can file a complaint for eviction. So after you respond to the court, the landlord is going to formally, again, just start the lawsuit. And then if the court grants a default eviction or sets a hearing, so that's either they're going to grant a default eviction contingent upon whether or not you view it as a tenant answer. So if you don't answer, it'll be a default eviction. And if you do answer, the court will set a hearing. And then if the eviction is granted, the eviction order is issued by the court and the tenant will be locked out. So for step 1, for notice to the tenant by the landlord, the tenant must be served by a constable, sheriff, process server, or an agent of the attorney. And usually, as I mentioned earlier, it's just posted on the tenant's door with a copy of the eviction notice itself mailed. And then there's 2 kinds of notices. So there's a 1-part notice. So typically that's just for non-payment of rent. So you have 30 days to respond typically, but after the Nevada CARES Act, you have 30 days if you qualify under that statute. And then for 2-part notices, for nuisance evictions, you have 3 days to respond. And then there's a 5-day unlawful detainer, but we'll get into that after I read through this. Also for 2-part notices, so there's so the next one is if there's a lease violation. So you're on notice for 5 days, and then you have a 5-day unlawful detainer period. So you would have to respond as a tenant after the 5-day unlawful detainer period. And then same with the tenancy at will. And then for a no cause eviction, you have 30 days or a 7-day plus, you have 30 days or 7 days, again, contingent upon the Nevada CARES Act. And then you have a 5-day unlawful detainer. So contingent upon whether or not you qualify for the 30 days or the 7 days. After that period, after the 5-day unlawful detainer period, your time is up to respond to the court. So if you do have a 30-day notice for monthly tenants, typically for no cause, and then if you are a tenant who is 60 years older or disabled, you can request an additional 30 days in writing to the landlord. And if the landlord refuses, you as a tenant can file a motion to the court, which is basically just asking them to put everything on pause until you guys figure that out. So for step 1, for 2-part notices, the first notice tells the tenant to leave or do something to fix the problem within the notice period. So for example, just going back for nuisance. So whatever the tenant's doing that is a nuisance, for example, you have 3 days to fix it under the Nevada statute. And then the second notice tells the tenant that the landlord intends to pursue eviction and the tenant has a right to file an answer with the court to defend. So again, within that 5-day period under the unlawful detainer thing on nuisance, you would have 5 days. You would be put on notice for 5 days to respond to the court. And then for 1-part notices, which is typically just non-payment of rent, everything is contained in 1 notice. So you would just have, if it's non-payment of rent, you have 7 days to respond to the court. So for step 2 of this, our summary eviction, during the notice period, the tenant can respond to the court. So there's 4 ways you can respond before the notice expires. And again, responding to the court is just filing paperwork with the court, just telling them what's happening. And so you can either, you as a tenant can fix a problem or issue before the notice expires. And then there's no basis for eviction, the court can evict you. You can move out as well, and then the court can evict you there. The tenant can file an answer with the justice court to defend against eviction. So I've already explained this like 4 million times, but again, so you're just responding to the court, you're responding to the eviction notice of the tenant, of the landlord's posted on your door. So this doesn't guarantee eviction without a hearing. So if you do answer to the court, there might be a hearing with a justice. And then if it is a 2-part notice, you must file your answer with the court during the second notice period. So that's the unlawful detainer period. So, or we don't recommend this, you can just do nothing. But again, as it says, please don't do nothing. And then if you don't do anything, the court can just order a default eviction. So that means that you don't get any notice and you just get locked out. So there is a fabulous piece of legislation that came out during the special legislative session. It is Assembly Bill 486. So it does create 2 defenses for eviction for tenants applying for rental assistance, which is through the COVID Housing Assistance Program. So it applies to all eviction types where the rent is owed, so except for nuisance. So as a tenant, if you are being evicted for anything except for nuisance in Nevada, you can raise this defense. So the first defense applies is if the tenant has applied for rental assistance and the application for the rental assistance itself is pending. So the important thing is with this piece of legislation is that you as the tenant, after you get a notice from your landlord, you have to file an answer with the court and mention this defense. So if you do raise this defense in the answer of the court will stay your case, which just means put everything on pause until the application is decided. And then if the rental assistance is approved and paid to the landlord, the case will be dismissed, you won't be evicted. And then the second defense under AB 486 is if the tenant is approved for rental assistance, but the landlord does not want to accept the back pay rent from your rental assistance program, which is typically CHAP or would be RAFT in Las Vegas, or the landlord won't cooperate with the process. Again, you as the tenant have to raise the defense in your answer to the notice for eviction, and the court will stay the case until the tenant proves the allegations, either that the landlord is refusing to accept it or that they won't cooperate with the process. If you as the tenant do prove these allegations, the case will be dismissed. And then again, to get protection, you have to file an answer with the court and raise the AB 486 defense. And the time period for this would be contingent upon which kind of eviction the landlord is trying to evict the tenant for. So for no pay would be 7 days or 30 days under the CARES Act. So you'd have that time to respond and file your answer to raise the defense. So step 3 is after the notice period, the landlord can file a complaint for eviction. So this is again the formal process of starting a lawsuit against the tenant. So if the tenant has not fixed the problem when the notice runs out, the landlord can file a complaint and they can ask the court to evict you as a tenant. So if the court grants a default eviction or sets a hearing, what happens after the landlord files a complaint depends upon what the tenant did. So either hopefully in this situation, you did respond and raise the AB 486 defense, or if you did not, after the landlord files a complaint, the court will issue a default eviction order without a hearing. So you don't have any chance to talk with the court. So the constable will post an eviction order on your door, and then within 24 to 36 hours, you will be removed and the constable will change the locks. And then if you did file the timely answer, the court will schedule a hearing for you and your landlord, regardless of the content of the tenant's content. And then a hearing will be set out at least 30 days after to allow for a mediation process. So here in Nevada, for eviction processes, we like to try and mediate things and not take them to court. So you and your landlord will, you as a tenant do actually get a mediator or an attorney to mediate with your landlord, so you guys can figure everything out. And if that doesn't work out at your hearing, the judge can grant or deny eviction, or they can dismiss or stay the case. And then last step, so if there is an eviction order and a lockout, if the judge grants an eviction at the hearing, or if the eviction is granted by default because the tenant did not answer, the court will issue an eviction order. So constable or sheriff will post the order on the tenant's door, and then you will be locked out with 24 or 36 hours later, and you will be removed from the physical property. So before you are actually locked out as a tenant, you can appeal the case to the district court. So unfortunately, there is a $97 filing fee to do this itself. And then you do have to pay a $250 bond fee to appeal the case. And then you will get that back if you win. And then the tenant, you can also file a motion to stay the eviction order, which is pause it. And then if that gets granted, the court does have discretion to pause the lockout for up to 10 days. And then, so for eviction sealing, when the eviction is sealed, the court case is removed from the public view. So some cases in Nevada are automatically sealed. So if your case is dismissed, it's sealed immediately. If your eviction is denied, it's sealed within 10 days. If there's no complaint filed by the landlord, it's sealed within 31 days after the tenant's answer was filed with the court. And then for non-payment of rent during COVID, it's sealed immediately. So it's not sealed if your eviction is not sealed automatically. You can use a tenant can file a motion with the court and tell the judge about the circumstances beyond your control that led to your eviction, extenuating circumstances surrounding the grant of eviction, and then the time passed since the eviction granted. So more is better. Trying to get it sealed. So then if you do leave property behind as a tenant after you move out, essential personal items, so medication, baby formula, etc., you have 5 business days after you, or after 5 business days after the tenant does leave, the landlord must give the tenant opportunity to retrieve these items. And if the landlord does refuse to allow you as the tenant to access these items, the tenant can file a motion with the court, which is just asking the court to make the landlord allow you to access your items, and then the court can allow retrieval. And in some circumstances, the tenant can be awarded up to $2,500 in money damages. So for other personal property that isn't essential, after 30 days, the landlord must safeguard your property. So the landlord can inventory the personal property, they can move it, they can store the property and refuse to return the property until the tenant pays the cost. So the landlord can't hold for payment of rent and other fees. So after 30 days, the landlord can dispose of the property if there was reasonable effort to locate the tenant and the tenant wasn't responsive, or if there was a written notice to the tenant of intent to dispose the property and the tenant does not respond, or 14 days has passed since the written notice and there's no response. So if you as the tenant disagree with the landlord's charges, or the landlord is refusing to return the property, you can file a motion with the court again and get an expedited hearing, so that will be quicker. And then I didn't realize that was it. Okay, so does anyone have questions? I know Nikki did.
Okay, Krista, I will unmute you in just a second.
Oh, it's like very specific.
Okay, Krista, feel free to unmute yourself and ask your question.
Hi, thank you. So one of the issues, I know it's not so, this isn't really case related because nothing's happening in courts yet. So that's why I thought it was okay to ask this. This is just regarding a repair. I was there in the office and they gave me the forms as far as explain the difference between essential and non-essential. There's a device in my house that shuts off my water. So I was told that's considered essential to fall under the 48-hour notice. So they didn't fix it within 48 hours. It's been almost 2 weeks. And they're sending a plumber today to get it. Now, in the meantime, I did withhold rent, and they filed something against me, which I'm coming to talk to you guys about on Monday. But the question is, when they go to remove this device, the plumber told me they're supposed to take it with, and I want to keep the device because I want to bring it to court when it happens. Am I allowed to legally to keep this device? that was installed, or do I have to let the plumber take it today?
Yeah. The device,
That's beyond our wheelhouse.
It's really funny. It sounds crazy, but it's a device.
Oh,
that
wait, sorry. Our attorney here can answer your question.
All right, so the first step in the habitability process is you would have to send a letter via certified mail or some other provable means, putting your landlord on notice that they have 48 hours to fix the issue. Did you
Yep.
send a letter to your landlord notifying them of the issue?
Yes, I sent an email and they acknowledged the receipt of it. I didn't do the letter, unfortunately, because I didn't know that. I was told to send a letter after the fact, which I am planning on talking to you guys on Monday and finding out what the next steps are. But they were notified and acknowledged the email.
Okay, so after your landlord failed to fix the issue, there were several things that you could have done under the statute. So you could have obtained other essential services and deduct the cost of rent, so you could have paid to fix it yourself and deduct the cost of the rent. You could have obtained other housing with rent stopping at the rental property until the problem was fixed. You could sue the landlord to fix it, or you could have withheld rent. Did you do any of those things?
I withheld rent, $500 of it, which is why they're now filed an eviction notice on me, because they said I didn't pay the whole rent. And they're saying I owe the whole rent, and they're returning my payment of $1,685 of my rent that I paid to them already. They're saying
so
not accepting it.
you can't withhold just a portion of your rent, and when the landlord fixes the issue, you have to release the full amount of the rent.
Right. I planned on today when the plumber showed up, I was planning on paying them $500, and I told them that in the email, and they acknowledged that. But then because of the fact that there's some other stuff happening, which I don't want to, make it about me here. Email. There's other stuff happening.
Fine. So listen. What document did your landlord serve upon you? Was it a non-payment of rent eviction notice, a 7-day non-payment notice?
Yes, correct. With the full amount of rent owed, not even the portion I owed. They're saying I owe the full amount, even though I paid 3/4 of it.
Okay, so if we listen back to those the discussion about the 7-day non-payment of rent eviction notices, you have 7 judicial days, which don't count weekends and holidays, to go file an answer with the court to defend yourself.
Correct.
If you file the answer, you're going to raise habitability as a defense. So in that tentative answer, there's a checkbox. You're going to check the box that you have a habitability issue, and you're going to attach whatever evidence you have. So that email that you sent the landlord that the water wasn't working at your property. You're also going to provide evidence of all your attempts to make payment to the landlord and your landlord rejecting that payment. Now, what's going to happen is it's probably going to an eviction hearing after you file your tentative answer. And if you have the rent, the judge is just going to ask the landlord to accept the rent at the hearing and dismiss the eviction case. So you are going to have to file an answer within that 7-day period, and you are going to have to go to an eviction hearing if you can't resolve it at mediation prior to the hearing. But if you have the funds to pay the rent in full at that time, the judge is just going to ask you to release it to the landlord, then he's going to dismiss the case.
So then I should not pay the additional $500 today that I owe, is what you're saying? I should just wait. I shouldn't do anything else money-wise?
No, so that wasn't proper for you to withhold the $500 because the landlord's fixed the issue and you can't withhold just a portion of your rent. So you really should have released the full amount. So
Well, no, but he didn't fix the issue yet, is what I'm saying. Like the plumber is supposed to be coming this afternoon. He's never showed up yet. And since June, when the device was first activated in 4 days without water, and I didn't understand all my options that I had.
So you can't withhold just a portion of your rent. You can fix the issue by paying the full rental amount prior to the expiration of that 7-day period, and then there's no basis for eviction. But you would still have to file an answer to tell the judge that in case your landlord tried to file a complaint. So yes, you should release the funds. If you'd like, if they don't fix it today, then you can follow the steps. You would send a formal letter to your landlord stating because he didn't fix the issue, they're going to be withholding your rent until he does fix the issue. And so you have proof that that's the step you're taking under the habitability statutes, and then you'll have evidence to a court.
Great.
If I were in your position, I would release the rent and then file an answer with the court, and then if it goes to hearing, the judge is going to dismiss the case because you cured.
Got it. Now, question for you. There's other issues pertaining specific to my case, which I won't discuss openly here. I'll talk to the attorney when I make the appointment. But is it better to wait and not pay the rent so I go to court and deal with all these issues that are you've hit a few issues here that are discrimination, like there's a lot of things happening.
No, it's not, sir. It's not better to wait because remember the summary eviction process, the judge can only award possession of property. So you can't ask the landlord to address whatever other issues you have with the property, because it's only about possession.
No, I meant about violation fee day.
Landlord, you're gonna have to file in justice court or in small claims to have your landlord address those issues for
Got it.
breach of lease or other issues like that.
Okay, so even like HIPAA law violations and that kind of stuff is all a whole separate thing. So I shouldn't, okay, so I'll just pay the rest of the rent today then. It's fine. Thank you.
Thank you.
Thank you, Vicky, and I believe Krista was next, if you would like to unmute yourself.
Hi, yes, I put my question in the chat regarding the fees, because when I've submitted other paperwork for people, we just have to fill out that other form and it's super easy, and then the fees are waived.
Okay, yeah, sorry, so I see your question in the chat here, I'm gonna read it for you guys. Is there any waivers for those fees? You're referring to the application, you're referring to the court fees, the $97 and the $250 bond.
Yeah, because there's a form you can fill out and they don't make you pay the fee for like when you respond, like the initial response. I don't know, like, because I know you may have been talking about appeals or something, and sometimes they just leave you out in the cold, so you don't have an option. But I know there's a form you can fill out, and I think it's a $97 filing fee. And so that I've done it a few times and people didn't have to pay. And then the other, I just wanted to mention too, if you really want to, put a thorn in someone's side, a lot of these complexes, they get tax breaks. And so when you call the Nevada Housing Authority, then they send someone out, because now it's an issue with the IRS. And so nobody wants the IRS on their asses. Excuse my language, but nobody wants that.
Question, I'm going to address it because the law students, we haven't discussed it. Yes, the form is called an application to proceed in form of papyrus. It's available with the packet for a tenant to defend themselves. So they're going to complete it and they're going to fill out their expenses and income and ask the judge for an order to waive the filing fees. So it does waive most filing fees. However, it does not waive the $250 bond for appeal. So if a tenant loses their case and need to file an appeal, that $250 bond is what stops the eviction from taking place until the district court judge makes a determination on the appeal. So it does waive most fees based on indigency, but it does not waive the $250 bond.
So in cases where it just gets spit back out and people are faced with having to appeal, are there nonprofits or anybody who would help with that? Because to help that, because it would stay the decision or something you said. I don't know. I wrote it down.
No, ma'am. During the pandemic, we had some funds in our office to pay them directly on behalf of tenants we represented. But we filed hundreds of appeals and we ran out of funds, and there's no nonprofit that can pay that now. So if the tenant really needs to stay on the property for a few more weeks, they'll have to raise the $250, which will be cheaper than renting somewhere.
Right. Okay. Thank you.
Thank you. And we do have some questions in the chat. I will read. We have two questions from A. The first question is, how is normal wear and tear defined?
I would think it'd be like reasonable, all right? Like reasonable wear and tear. What we think a reasonable person would think is wear and tear. Anything beyond reasonable would be not normal wear and tear. What happens in the event landlord is 1 day late with the breakdown? The breakdown.
I'm assuming that means to break down the cost if there is normal wear and tear.
Oh, right.
Security deposit. Yeah, they're keeping the security deposit, stating that they gave me a breakdown of stuff, and I mean I have video and pictures of the property before and after, and it's similar. I was there for 8 years, so it's very close to what it was like when I got it. They never replaced the carpets, they never did any type of routine maintenance. So I mean the property is in, it's like I said, similar condition to when we got it. And if I understood you correctly, wear and tear is just going to be defined by the judge if we get there.
Yeah, I think it's very vague.
Well,
the way it is.
it's just like it's a reasonableness standard, but again, it's like obviously if you punched a hole in the wall.
Yeah,
that's
there's
not
no
normal
holes
wear
in
and
the
tear.
wall. Okay, I got it.
But like if you spilled wine on your carpet, that's
Sir, if you dispute what the landlord's move out statement and with holding of the deposit account statement says, you can file a motion with the court. We have that sample form available for you at the Civil Law Self-Help Center. And so you don't need to file a separate action. You're just going to file a motion with the court, and the court's going to determine what reasonable wear and tear is. So you're going to attach your pictures of the property. Hopefully you have them upon move in and move out, and attach pictures of your HUD move out statement if you have it, a move in statement. And then the judge is going to determine if what the landlord withheld was appropriate. The judge can award double damages in those cases. And so if the landlord inappropriately withheld more of your security deposit than what they're entitled to, the judge can award double damage of your security deposit.
So I have my pictures when I moved out, but they refused to allow me to be there during their inspection. I have it in writing where they say, nope, that's not part of our protocol. You cannot attend our inspection. So it was kind of fishy that they would not allow me to be there. I mean, I got the video from the day that I moved out, but I don't know what happened in between those 2 days where they completely refused to allow anybody to be there other than their team.
Well, that's common, so they don't have to allow you in the property upon their inspection of the property, but you're just going to present the evidence you have to the judge, and the judge is going to make the determination of whether it's reasonable wear and tear based on what you're saying.
Thank you.
Then we have one more question. Did you see it?
There is some comments in the chat, but there is just to provide us with the NRS for habitability of dwelling unit.
No, for Mickey's question.
So for Mickey specifically, I don't want to get into the details of your case, but yes, Legal Aid Center of Southern Nevada does help with cases like that. So you can either call or just come down, and we do have attorneys that can help you fill out the paperwork.
Okay, great, thank you. Because I was in there to do the general stuff, but now that they filed, it's a totally different deal, and I don't feel comfortable doing it on my own.
Yeah.
All right, thank you so much. I'll see you on Monday then.
Are there any other questions, or do we have any in person?
I have more of a statement than a question.
Okay.
That was beforehand.
Do we have any more questions online? What was your name?
My name is Sean Zay, so I work with Plan in Plan.
Yeah, no, you're good.
Okay, so I work with Plan. We're a nonprofit organization that does advocacy for the state of Nevada. And we're working on tenants' rights and rent regulation and things like that for the upcoming legislative session. So I'm going to drop a link in the chat if anyone is interested in volunteering or learning more about how they can share their story, or maybe how we can change some of these laws. Talk to me. So that's my secrets.
Plan is great. Okay, then we have one more question. I'm gonna read it. Oh, okay. If I have not received anything from my landlord within 30 days of move out regarding my security deposit, can I sue for double the amount?
Sounds like, yeah, I mean, it sounds like they should have definitely said something. We covered that they have to provide a, like the list of problems that they said they need to deduct from, and certainly if they're deducting the whole lease, I think it's a big issue. Where was it? Where discuss that?
Just to the left. And then she said, I already sent a demand letter.
Here. Right, and itemized accounting showing the deductions, but you need to get an itemized. So the landlord fails or refuses to provide an accounting, tenant can sue for double deposit. So I would say, yeah, go for it. All right, that sound right?
Yeah, so here's the issue. the landlord has an obligation to send that move out statement to the tenant's last known address. Well, guess what? That's the rental property where the tenant was previously residing. So a lot of times tenants don't receive the move out statement because they haven't updated their forwarding address with the post office. So what I'd suggest you do is you reach out to your landlord and ask them how come they haven't provided you a return of the security deposit or the accounting statement. But if they just didn't prepare one or they don't provide one, then yes, you can sue in small claims for double the value of the security deposit because the landlord has a duty under Nevada law to provide it within 30 days.
Did that answer your question, Candace?
My mail was forwarded.
Yes. Okay, she said yes, thank you. I don't know what to
With this one, right?
Does anyone else have any other questions? Also, thank you for being here, Plan. Plan is fabulous.
What is plan?
Progressive Leadership Alliance of Nevada. So it's just a bunch of progressive like organizations in Nevada that come together and we work. I think we, yeah.
We wear shirts like this. We walk around and take pictures from officials.
Okay.
Are there any more questions? I know Mickey wanted to stay, but if not, thank you guys all for joining us. Hopefully this was informative.
Are you saying I can ask the question or no about the MLS ad?
You can, but just again, just be aware that there are other folks in here.
I understand. It's more of a question like if you go to rent a property and you use an agent who pulls it from the MLS and there's things in the ad that say specifically like a guard gated community type of thing, and you move into the property because you do it sight unseen because you're from another state, and then you find out that the gate is only for the cars coming in and it's wide open in the back area. Is that something that's like, that you can do something about, like, either get out of the lease or sue for it or reduce the lease? Because it turns out that, the back of our whole HOA backs up to like a wide open area, which is open to coyotes, which I never would have rented because I have dogs and I've had an issue. So stuff like that comes up. Like, is there any repercussion or am I just SOL? Kind of is my question.
So the answer to that question is, it depends on what's in your lease agreement. So just an MLS listing is not sufficient. It depends on what you agreed to with your landlord through the contract, which is the lease agreement. So you'll have to review that and see what it says about a guard gated community. If you think that the landlord breached the lease, you have some rights under the law, but it depends if it was a material breach or not, right? So you may be entitled to terminate your lease early because you can allege that the landlord materially breached the lease by not providing a guard gated community. But it's really dependent on the facts of your case and whether the lease, the landlord was obligated to provide that service to you.
Got it. Okay, thank you. I guess it'll be another thing I'll bring up when I meet with you guys. So thank you so much. Appreciate it.
Do we have any more questions from anyone online?
Thank you guys. I really appreciate all your help.
Thank you. I think, are we good?
Do not see anyone else? No hands.
Going once.
Actually, I'm sorry. So
You guys,
one more question. I have someone who's listed as a tenant on my lease, and she's sitting here with me and wanted to ask a question. Is that possible?
sorry that you guys will do some canvassing the sequels.
Okay, are we done? Well, thank you, everyone.